I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial.
And we are back, and we are back. Want to thank y'all for watching. Go ahead and hit that like button. It helps us out a ton, and it only takes what? The minimal amount of effort from you. It helps us out, and it helps you because it helps us. So go ahead and hit that like button. Y'all, we have another mistrial motion. We are going to show you a video from Miss Abbasi from yesterday. Then we're going to show you what happened this morning. Miss Abbasi, it didn't go her way, y'all. Didn't go her way, as you already know. But I want you to take a look at what happened so you can be the judge as to who was right. But Miss Abbasi got her get back, y'all. I think on cross-examination of this first witness, Miss Abbasi went all the way in and then some. So we're going to show that to you. So again, without further ado, like, comment, subscribe, and let's get into it.
All right. I think tomorrow we'll have Detective Hogan and the ME, and then move on to whatever the next group of witnesses is going to be. Okay.
We also have one of the former co-defendants, one of the co-defendants.
Who? One of
That we've already been discussing with Mr. Lee.
I was trying to find out if the state was going to be calling.
Oh, right. Okay. Okay. All right. Okay. Is there any other matter we need to take up this evening before we leave?
Court's not addressing. Yes, I understand that something could be used against, I'm just using his name, but Mr. Kendrick, not against the others, but
Right.
But then it says that you can use the other evidence, and there's no instruction that that's only if a jury finds beyond a reasonable doubt that one or more of the persons entered into a willfully and knowingly. And
Right, but we're talking about overt acts. I mean, they're going to have to, that's another step or portion of what they're going to have to decide. And obviously they're going to get full instructions at the end of the trial. So I'm not going to get into, here's how you're going to consider all of these different parts of the RICO count, you know.
I do understand, but as a listener, I guess, for a juror, they don't even get to decide the acts unless they first find it. They could do it any order they want, I guess, but they first find that there was a willful and knowing joinder of the conspiracy.
Sure, that's a part of what they're going to have to find as to each defendant before they can convict anybody.
And I'd like that language in any instruction, because otherwise, you know, let's assume that this trial ends, the state rests in December. That's approximately a month and a half, maybe 2 months from right now. Meanwhile, the jurors are being conditioned, in my words, from this honorable court's instruction, that, hey, yeah, we can use evidence against everybody except certain evidence. So I'm going to realize that this is against everybody before there's been no instruction, to my knowledge, in this entire case, that they have to first find that there's a conspiracy, that a person joined the conspiracy. So
They're not supposed to be deliberating until the end of this case, the close of all the evidence, all of the jury instructions. So there isn't a danger of that.
okay, well, that's my problem.
All right.
Because
Well, I'm not going to give them a full kind of mid-trial mini instruction on how to consider RICO. They're not
Okay.
supposed to be doing that yet.
Okay, I'm not trying to say a full instruction, but just a line, maybe. I put it in.
I mean, I can say, you know, I'll give you further instructions later
on
how to consider all of this.
and whether a conspiracy even exists or a person joined a conspiracy. That's what I'd like, because I do find, and that, yes, I understand that though it be instructed later, but I do find that it is, jurors should have some context of this instruction. This instruction standing alone seems like it's already, there's a suggestion. I'm not saying the court's doing it on purpose, by the way, but there's a suggestion that other evidence can be used against everybody. Well, that may not be true.
I'm not, I'm only saying it as to if the state presents evidence aside from the guilty plea as to overt acts 56 through 59, and then aside from Mr. Ryan's trial conviction as to overt acts 79 through 81, which, I mean, they're certainly doing that for the murder of Jamari Holmes. They're doing it right now. So if I guess I don't believe that it is broader than what this is saying, which is specifically as to those enumerated overt acts.
Now, I would like something, if you, ladies and gentlemen, find, based upon my instructions that will come at the end of the case or at an appropriate time, that one or more of the people on trial knowingly and willfully joined a conspiracy, and then go into something about then you may not use the guilty plea or verdict, whichever,
All right, well, I
against anyone
appreciate
else.
that, but I don't think that's necessary,
Okay.
and I don't think that this misleads them into thinking anything at all
Okay.
wrong, really. Okay.
And
So,
I still believe my original that the evidence shouldn't come in at all because I'm struggling with the instruction. So,
all right, well, I
with that
think
being said.
in terms of if anybody would prefer the language, you may not use this conviction in your consideration or deliberations against any of the other defendants in this case. It is not evidence of anything against these other 5 defendants. Each defendant has a right to have his guilt or innocence determined by the evidence presented against him, not by what happened with regard to a criminal prosecution against someone else. That's one version. The alternate version is you are not to consider the co-defendant's, whatever it is, conviction as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of, charges or something. I don't know what that language is, but any preference as to which of those two the court uses? No, nobody cares. Okay.
I can't. I don't want either one. Sorry.
Well,
either one. And I'd
I'm
like to-
definitely going to give one or the other of them, because if I don't give one or the other of those, then it will be reversible error in the event that there ever is a conviction in this case, which of course would be ultimately a benefit to your clients to build in reversible error, but I would prefer not to do that because the court's job, to the extent I can, is to avoid any error at all, much less reversible error. So I'm going to give one or the other versions of that language. Does anybody have a preference as to which version of that language the court will give?
Your Honor, can we, since I have a preference, I still maintain my objection. I don't think it's reversible error if you keep out these pieces of evidence, and that would be my preference.
No, I don't think so either, but that's also not fair to the other side.
Can we just huddle for a minute so we may have
And
a
y'all
split?
don't have to tell me right this instant. I just need to know before the conviction is going to get introduced, which may be sometime today.
Yes, Your Honor.
Okay.
And if they're huddling now, once they're finished huddling, we just have another announcement to the court.
All right. How about announce, and then if they want to huddle, they can huddle.
And good morning, Your Honor.
Good morning.
The state does intend to call Mr. Lee this morning.
Okay.
He will probably be our third witness this morning.
right.
I know we were, Miss Abbas and I were supposed to speak very briefly. After they're huddling, we can have just 2 minutes to speak.
Well, I may have them huddle later
Okay.
because the Wooney Lee stuff's more pressing, because you can tender the conviction, in any order.
Yes, Your Honor.
So on the Wooney Lee evidence, is there any objection that still needs to get hashed out?
Yes, Your Honor.
All right. Okay, and then if so, where's the easiest place for me to find the
Your Honor,
evidence?
if I may, there's something we wanted to address first.
Okay.
Your Honor, I've got some members of the defense side here taking a look. Our understanding, and if it turns out to be wrong, it turns out to be wrong, was that the state was undecided yesterday as to whether they were going to call Mr. Bernard Mitchell. I know at the lunch break, Mr. Hiles was on the stand. His text messages had already been admitted. We went back to speak with him. The state went back and attempted to speak with him. So at that point, my understanding was it was still up in the air. I can be wrong. My understanding was it was still up in the air. Per Your Honor's request, we had discussed as many things ahead of time as possible. The discussions with the state were, and it was very clear for both sides, that we were not going to be objecting and not asking this court to litigate Mr. Mitchell's Instagram records because the state was going to call him. Yes, with them coming in, there were portions that we intended to use with the understanding that that is what would come out in terms of evidence. His messages would come out, so we would want another section in there. If the first section is in there, we would want the second section in there. But he's certainly not our witness. The evidence he presents is not a theory of the case that we would have brought to the table. And so now the state does not want to call him, and I think we're faced with a confrontation clause issue because we relied in good faith on our discussions with the state. We didn't go through and take the court's time to say this is conditionally admitted based on this happening. So we simply relied on what they represented to us. We had the evidence, came in, it was read out. I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial. We'd like to be able to rely on what we were told. And like I said, we're checking to see if there was something definitive on the record. But if Mr. Mitchell is not testifying, then we feel we have no option but to ask for a mistrial.
Would the state like to be heard on that?
I guess the state's response, Your Honor, is that the state, after the lunch hour, indicated to
Talk into the mic. Pick one up, maybe.
the state after the lunch hour indicated to the court, as well as counsel, at least for Mr. Ryan, indicating that we were not going to call Mr. Mitchell, basically because he told not only the state but defense counsel that he wasn't going to say anything when he came onto the stand. That was the same thing that was told to us by Mr. Uten. And my recollection is that it was an either or is what the understanding was. It was we were going to maybe call either Mr. Uten or Mr. Mitchell, and yesterday we decided neither. So I don't know how there could be a confrontation issue that's being claimed today. If we decided to put Mr. Uten up yesterday and not Mr. Mitchell, the records would have still come in the same fashion without Mr. Mitchell testifying. More importantly, before any message came in as it related to Mr. Mitchell, the state indicated to defense counsel that we were not calling Mr. Mitchell. We indicated that to the court as well. And
I don't remember y'all indicating anything to the court until the end of the day, y'all. But what I was told by the deputies was that the state had very clearly said they can be transported back. We are not calling either of them. And that was at or right after the lunch hour that I was told that. I asked yesterday morning, is this an either or? And yesterday morning, the state was definitely indicated, you know, it might be one, it might be the other, it might be both. We don't know yet. We still need to talk with everybody. And then we just went on with the trial, and they didn't, you know, after lunch, they went back because y'all had made that determination, and you certainly communicated that to the deputies with regard to transport. And you are making the representation that you also let the defense know that? Did y'all disagree that the state let y'all know they didn't intend to call either witness?
Excuse me. At the very end of the day, I had inquired to the court, said, discuss what's going to be the order tomorrow. And I
Right.
said, well, Mr. Mitchell, Mr. Uten, checking.
All right. I think tomorrow we'll have Detective Hogan and the ME, and then move on to whatever the next group of witnesses is going to be. Okay.
We also have, we have one of the former co-defendants, one of the co-defendants.
Who? One of
That we've
them-
already been discussing with Mr. Lee.
I was trying to find out if the state was going to be calling.
Oh, right. Okay. Okay. All right. Okay. Is there any?
Mr. Kokomo took a look, and before lunch, what was represented to the court said, who are we going to get to? And they said, we may not get to him today. So
That was before lunch.
that was before lunch, and then we came back in, and everything was published.
And everybody I mean, not everybody, but counsel for Mr. Ryan and counsel for the state spoke with, I guess, Uten and Mitchell over the lunch break.
We went back. He didn't want to speak with us. That's fine. We went separately from the state.
Right.
We didn't discuss anything with the state about who would or wouldn't be called at the lunch. And I don't believe before we started in the afternoon. That's not my memory. The announcement before lunch was we may not reach him today. They spoke with him. Obviously, at the end of the day, I still thought they would be called.
My recollection is after lunch, I was sitting there. Ms. Abbasi said, so you're not calling Mitchell? And I said, no, we are not calling Mitchell. That's my recollection before Mr. Howes began testifying after lunch, and we didn't call Mitchell. And the messages came in unobjected or not objected to, and there's been no conditional admittance of evidence that's been permitted
There has not.
or agreed to by any of the parties during the trial of this case, at least at the time that I've been here. So it's my indicator, be the state's opinion that any objection to the messages that came in are waived at this point.
Your Honor, our response is, we have difference of memory. That's fine. It is what it is. If the state knows they're not going to call him going into it, I don't think it's fundamentally fair for them to publish and then say, ha, you missed it. I don't think that's good faith. As far as, no, we didn't conditionally admit it, because we've done everything we can, at least for Mr. Ryan, to avoid taking up the court's time. This is what it was. We all agreed. We all understood. So that's how we proceeded. And now here we are, and we're stuck in a position we don't want to be in.
Well, I'm not quite sure what to do with this. I have a representation from Mr. Abadi that the state communicated to defense counsel that they were not intending to call Mr. Mitchell or Mr. Uten, and that was communicated prior to Mr. Hiles' afternoon testimony in which this evidence came in. And Ms. Abbasi, you're saying, well, it's not my recollection, but I could be wrong. That might be. So
I will not say my memory is perfect. I have no memory of having that conversation after lunch. I'm not going to say, Mr. Abadi's. I can't promise you my memory is 100% accurate, and I'm certainly not getting up and saying that Mr. Abadi's lying. I'm not going to do that. But I have no memory of that conversation at all. And, as I said, I brought up at the end of the day, what's the order of the witnesses? When are Mr. Mitchell and Mr. Uten coming in?
I don't remember that.
I had brought it up when we were asking about witnesses because I didn't know if the sheriff needed to bring them over. And that's what was coming up.
Are you saying that you on the record asked when Mitchell and no, you didn't?
That was at the very end of the day. We were just
Amongst counsel?
I believe Your Honor was on the bench when we were discussing just who are we getting to tomorrow.
Yeah, I asked who we were getting to tomorrow. I don't recall you saying when are we getting to Mitchell and Uten.
Well,
I don't recall the two of them being mentioned at all at the end of the day.
I know I asked the state at that point, oh, you're not calling him? No. And at that point, the evidence had already been admitted.
I'm asking you, did you make that statement on the record?
I don't believe so.
I
We can
don't
check the
either.
record, but I don't think so. I think the last statement on the record was we may not get to them today.
I don't recall that statement on the record or off the record. This is all a surprise to me this morning that now there's some debate about it, because everything I knew post-lunch yesterday, although through the sheriff's office, not through the state or the defense, was that a decision had been made and communicated that neither of them was going to be called. I mean, can't really do much else with I don't see a basis for a mistrial. So we need to deal with Wooney Lee's evidence. And y'all are just going to have to communicate or put more things on the record or something if you want to avoid misunderstandings in the future.
That's fine. We'll litigate everything first.
Or just put on the record your understanding.
Yes, Your Honor.
So if the understanding was these will come in if Mitchell testifies, just say, we talked about all of this and we don't have any issue as to, X, Y, and Z. And these things we've agreed are going to come in if Mitchell testifies. And then there'll be a record of it and everybody will know what they're dealing with.
I mean, I guess the state can make the suggestion. I mean, we can call him and the state will have no questions for him and then defense counsel can cross him if that will solve the issue.
I mean, at this point, he might have yet again been sent back, even though my staff was making Herculean efforts this morning to try to get him over because somebody wanted him. At the bench, y'all said, nope, that's fine. We don't need him. And by y'all, I mean you, Miss Abbasi, said, that's fine. We don't need him. If y'all aren't calling him, fine. So we just communicated to the sheriff's office, they don't need him. I don't know where he is at this point.
Okay. And Your Honor, Mr. Kokomo checked at the end of the day, I did inquire for the court, who do we need tomorrow, and gestured over to the door. And then that's when Ms. Love said, we've talked about it and we're not calling him.
All right, well then, that's even more of a record against your recollection.
I guess I don't understand. There wouldn't not have been any reason for me to ask about whether people were coming from the back after the evidence had already come in if I knew he was appointed to be testifying.
So you're saying you pointed towards the holding cell doors.
Right, asking about witnesses for tomorrow.
All right, well, that is no record upon which to grant a mistrial. So let's get to the Wooney Lee evidence.
Coming into today, have you had a chance to review the interviews you did with the witnesses you spoke to?
Not all of them, but yes.
Okay. You haven't had a chance to review them?
I haven't reviewed, I reviewed Mr. Mitchell and Mr. Uten's recently. The others have not.
Okay. All right. So I want to start. You've been an officer for quite a while, yes?
Yes.
And so you know that when you are getting information from people, it is of the utmost importance to make sure it's accurate, right?
Yes.
And that's one thing you were doing with Ms. Smith, is confronting her with facts to test whether what she was saying was accurate, correct?
That's correct.
All right. And especially in a situation kind of with young people, they may not always be fully forthcoming in the beginning, correct?
It's not limited to young people, but yes.
Right. Especially if they think there's something they could get in trouble for, correct?
Yes.
All right. And the folks that you were speaking with in this situation, they were not, well, the two young men you spoke with, they were not lawfully allowed to have weapons, were they?
No, I don't think so.
Okay. So that's something they theoretically could get in trouble for if they admitted to it?
Yes.
Okay. So when you're speaking with them, when you're speaking with Ms. Smith, You're asking questions to make sure you can verify things. One of the things you told Mr. Mitchell you would do was get his Instagram records, correct?
I may have, that doesn't come to mind off the top of my head, but it would be something I would do, but I don't remember if I told him that.
Would it help refresh your recollection to see a copy of a transcript from that interview?
Sure.
He's on the stand. He can repeat what he said.
That doesn't make it not hearsay, but
I mean, I can ask whether he asked somebody.
I think it's not hearsay in this circumstance, so overruled.
I mean, in this circumstance, it would be.
It's overruled.
Okay.
So.
So were you planning on getting Mr. Mitchell's Instagram records?
I may have been. It's hard to say. This is a lot of years ago, so it's part of my tools that I use for in each or any case that I have that I work. If there's an opportunity to pull those, and I need those, then yes. But I don't remember if I wrote a warrant for his Instagram or not.
Okay. You said if you have the opportunity, you certainly had the opportunity, right?
Yes.
Okay. And with those, if you'd had them, you could come back to him and say, hey, was this true? Was this not true from what you told me, correct?
Yes, I could, yeah.
Okay. And Mr. Mitchell and Mr. Uten, they were both cooperative, correct?
Yes.
So if you wanted to follow up with them, they gave you no indication that they wouldn't speak to you or anything like that. They were readily available.
Yes, not at the time they were cooperating with me that day, yes.
You didn't attempt to contact them any other times, though, did you?
I don't recall doing so, no.
Okay. So in this case, do you recall what search warrants you did take out?
No, not all of them, no.
Okay. Do you recall taking out warrants for Instagram records?
I do.
Do you recall whose records you requested?
No, I got little rods. I got Bally's. And without going through the index on my report, I can't tell you exactly, but I know I got little rods and I got Bally's. I got Rodelius Ryan's and I got Damon Blaylock's. May have gotten Mariah's and Brazy's as well, the Tyara Hartfield and Miss Smith.
Okay. What was your purpose in getting those records?
It's any information there that might help with the investigation.
Okay. Did you look at those records?
Not personally, no. I looked at some of the pictures. It comes in a format. Again, as I indicated, I'm not a computer guy. I'm not even on social media. I gave that information to somebody who could put it in a format that was easier to read, and then those people looked through it, and they let me know what they found.
So it wasn't for you to get more information. Someone else was supposed to get more
The
information.
information is going to come to me. It just didn't come through me.
So at what point did you get the information of what was contained in those Instagram messages?
When they gave it to me, I don't know what day it was.
Who's they?
I don't remember who the analyst was that did the examination of those records.
Okay. And the examination of those records, I would assume you included in your report?
Some of them, yes.
Some of them. Could you let me know then when? I assume if you put them in your report, it says then when you got them, correct?
It says when I put it in the report. Let me see.
I mean, that's something you would put in the report, right?
One that jumps out at me was from February the 26th of 2019. Somebody sent me an Instagram post on that day, and it was a short video that showed Mr. Ryan riding in a car.
Okay, but that's not the Instagram records, right?
It's from Instagram.
That's not the Instagram records for which you obtained a search warrant to get so you could get more information, correct?
I haven't verified it, But if it came from his Instagram and I got a search warrant for his Instagram, then yes, it would be in there. I
Right.
just got it before I got the search warrant records back.
I'm sorry, if you
It
could
was
repeat that last
posted.
part.
It was posted. Somebody saw it. They sent it to me. If my search warrant had not been executed and the information sent back to me at that time, it would be included in both records. But I got it before the search warrant records came in because somebody sent it to me right after it was posted.
Okay, I think a second ago, because you said you didn't confirm it, right?
You're going to have to. I don't understand what you're saying. I've confirmed it. Yeah. What are you talking about?
Well, I think about the content of the messages, you said you did not confirm with the records.
I just said I'm assuming.
Right.
If it's in his Instagram records, I received it before the records came back from the search warrant. I'm assuming that information that I received that day before the records came back would be in the records when they arrived to me.
Okay. So without those records, having looked at them, there was no way for you to go to Ms. Smith or Mr. Mitchell or anyone else and say, hey, you told me X, Y, Z, but your records say something completely different. Right?
I did not do that, no.
Okay. You could have done it though, right?
Yeah, sure.
And that would have been confirming, right?
Sure, yes.
I want to ask you about what you testified to earlier about the actual crime scene. Mr. Abadi asked you questions about where you found certain things. Do you remember that?
Yes.
And you answered questions about where you found those 7.62 shell casings, right?
Yes.
But you didn't actually find those casings, did you?
No, I did not.
Those photos, you weren't there when they were taken, right?
No.
You never saw where those 7.62 casings were.
Not physically, no.
So when you say you found them, you didn't find them. Someone else did.
I said they were found. I'm not sure that I said I did.
Okay. When did you learn about those casings?
Later on the same day that the murder happened, I was at the office when I got the call.
Okay. And when you spoke with Mr. Mitchell and Mr. Uten, were you aware of those casings?
As I recall, it was around the same time. I don't remember exactly the sequence of events, but I spoke with them later on in the morning. It was sometime around the same, a lot of things were happening at the same time, that we got the call about the shell cases. That's one of the reasons I did not physically see them, because I was busy at the office. So I asked the responding officer to collect them and supervise that. But I don't remember the sequence of when exactly they came in.
Okay. Would it help refresh your recollection to see a copy from your trial testimony?
Sure.
I'm sorry, not your trial testimony, the last proceeding, several proceedings ago.
Okay, sure. All right, so what's your question again?
If when you spoke with Mr. Mitchell and Mr. Uten, you were aware of the 7.62 shell casings?
I was aware that they described to me two shooters, but I don't recall if I knew about the shell cases at that time. I may have, I don't remember.
You said that they described to you two shooters?
Yes.
Okay. You've got a transcript in front of you, so you've testified about this before, correct? This matter?
Yes.
Okay. And you don't recall attorneys asking you at length whether anyone besides Ms. Smith mentioned two shooters?
I'll read here that they were asking me about that, yes.
Okay. And your testimony was that Ms. Smith was the only person who said there was two shooters, right?
Yes. That's what it says here.
I mean, when you...
Wait, before we get too far around here, let's make sure we got the right context.
If you want to flip to page 1,100.
No, let me read these first.
Okay.
On page 1076, as I recall, they were asking me about my interview with Ms. Mitchell. and I had mentioned to her that I had 2 sets of shell casings. They were trying to determine if she.
Okay, well, I don't need you to testify about what someone else was trying to do.
So what I'm saying is context matters. In this particular instance, I was describing my interview with her, and in the process of the interview, when I was confronting her with the evidence, I told her that I had 2 sets of shell casings.
Yes, I understand that.
You said page 1100?
Yes, sir.
Okay.
So having reviewed that page, Mariah was the only person who said there was 2 shooters, right?
According to that transcript, yes, ma'am.
That was your sworn testimony under oath, right?
That's what I said. Yes.
All right, so that was the truth that you said it then, right?
Yes.
And I'm going to back up for a moment. I think you said Mr. Mitchell and Uten, they told you about not 7.62, but a weapon which would have fired larger shells. Is that right?
Yeah, they described a long gun coming out of the breezeway. Yes.
Okay. And when you were speaking with them, that was not consistent with the scene as you had seen it, right?
Again, I don't remember exactly when I got all the information about the shell casings. So at that point, I was getting his statement, and I took it as he gave it to me.
Did you not previously testify about the shell casings? I did not know about it when I interviewed Mitchell and Uten.
Okay, well, if my recollection was that then, I don't remember that now. If I didn't know about the shell casings then, if that's what I said, then that's what I said.
Okay. But you didn't confront them with what, at that time, would have been their testimony inconsistent with the scene, right?
No.
Okay. And they both told you 1 shooter.
Sustain.
The number of shooters they told you was not the same as Ms. Smith, correct?
That's the same question, just worded differently.
We've already been through this.
I'm going to overrule that one.
Bernard Mitchell described the shooter coming out of the breezeway, and also the shooter when he was going around. He was right beside he described the person right outside the car shooting him in the car.
So that would be.
Described dreads and a hoodie.
So that would be he described to you 2 shooters, based on what you just told me.
Yes, based on my just reviewing my interview with him the other day.
All right. I'm going to have you take. So you don't recall testifying that Mr. Mitchell actually never said anything about 2 shooters?
I got a sneaking suspicion you're going to show me that I did. But as I sit here, I don't recall that, no.
You were able to review your interview with him, correct?
Yes, I did.
Okay. You still have that transcript in front of you?
No.
Get back.
Oh, is this it?
Yes, sir.
Oh, okay.
You could take a look and see if that helps refresh your recollection about whether he told you there were 2 shooters.
It may or may not refresh his recollection, but I'm going to object to hearsay from Mr. Mitchell. I'm going to object to hearsay.
This is impeachment of what the officer previously said.
Which was hearsay.
I'll let you ask about whatever he previously said.
Do you have a page or an area that I need to look through? Exactly, it's a long interview.
No, sir.
How many pages are we talking about?
Can't see, maybe about 20. I can't see if that's right. It could be more. You know what? We can come back to it. We'll probably have a break and you can take a look and get back to me.
Okay, sure.
Cool. So when you went out to the scene at the time, you were looking to speak with other witnesses, correct? If there were any.
Originally, when I first got to the scene, yes.
Okay.
Yes.
You were trying to speak with as many people as you could, right?
Yes, I did.
Okay. And you had access to the cab reports and the 911 calls, correct?
Yes.
Okay. And you had access to the 911 calls themselves, correct?
Eventually, yes, I did.
Okay. And anyone you spoke with, you would have put that in your report, correct?
Yes, most of the general information. I don't necessarily put all the details, but yes.
Okay, but like their name, right?
Not always. If they don't wish for their name to be included, if I can exclude them, I will.
Fair. But you never spoke to the 911 callers, did you?
No,
Even though you had their name and contact information, right?
that's right.
Even though you were aware that one of them wanted to speak to the police, right?
If I was aware of that, I would have spoken with them.
All right. I'm going to approach you with what has already been previously admitted into evidence and marked as states 1 NN Nancy.
Okay.
Okay. And that is one of the cab reports you've reviewed, correct?
It appears to be a CAD report from the case. I can't say I reviewed it, but this seemed to be from the case, yes.
So you didn't review the cabs, or you did?
Well, I look at it, I verify that it's got the right address on there, and if there's any information as the case progresses, and if I need to get back in touch with anybody like a 911 caller, I would do that.
Okay. So you didn't see the...
And I would use the CAD report to get that number
Okay.
and name. In this particular case, I didn't see the instance to it. Didn't need it.
You didn't need to see the person who wanted to speak with you?
I wasn't aware of that person.
So you didn't review the cab?
I looked at the front page. I didn't read every word. No, ma'am.
Okay. And so you didn't listen to the 911 calls?
No.
Okay. So if you're trying to speak to as many witnesses as you can, why wouldn't you speak to the 911 caller who wants to speak with you?
Again, I didn't get the word that they wanted to speak with me, or I would have. My plate was pretty full. I talked to a lot of people when I did a lot of work that day.
Oh, okay. You were too busy.
Yes, I was busy.
Okay. So when Mr. Mitchell and Mr. Uten, no, let me back up. The photos of the 7.62 shells, you didn't take those, correct?
I did not.
Okay. Were they just sent to you? Is that right?
Yeah, they were included with the report, yes.
Okay. And so is it from those photos you pieced together, let's see the exhibits, say 10 NN that you've drawn a line on? 10 NN, you drew this line, correct?
I did.
Okay. And this Earth image or whatever it is, that accurately depicted the apartment complex as you observed it, correct?
That's correct.
Okay. So, and the line on the left side where it starts, that's your belief, that's where the 7.62 shell casings were?
That's correct, yes.
All right. I'm going to put up on the screen for you what has been admitted as, I don't know if it is the share screen. Thank you. All right. So, looking at 59 NN, what is it you see next to kind of that entryway, exitway, by the sidewalk to the building?
Well, I see a satellite dish and an AC unit.
Okay, AC unit. And then you were standing at that AC unit looking at the parking lot. What is to your right? We have a line of bushes.
I'm turned around here. I don't understand what.
If you're standing next to that AC unit with the AC unit on your right, you're looking at the parking lot. Do we have a line of bushes there?
Yes.
All right. Could you flip back to 10 and then? So looking at 10 NN, officer, you said it was consistent. What happened to that line of bushes?
They're not there.
Okay, what happened to the AC unit?
It's not there.
So how is that possible?
Well, when I got the information from the officer, I memorialized what he told me, what he found. He said it's by the Y building. I was assuming that Y building was where I indicated right there.
Oh, okay, so
on
you
the
just
map.
assumed that.
I did, yeah.
Okay.
It's in the same complex. The picture with the shell casings is in the same complex. I think it's in the next building back in that little courtyard.
Okay. But so you didn't go out to the scene and see where those 7.62 casings were, right?
I've said that a couple times.
So you can't say for sure, actually, that 10NN is even where those were found, right?
That's correct.
Okay.
I can say they came from the complex, but
Fair.
exactly where in the complex, I don't know.
Fair. And with this image, I'm going to point you to, I guess I can't really point to it. That corner right there, right?
Yes.
That's where Ms. Smith indicated one of the shooters would be, correct?
I don't recall that.
Where do you recall she said the shooters were?
She said, if my recollection is correct, she saw somebody walking out of the breezeway.
Here?
Yes. I believe, yes.
Okay. So all those casings should be right there.
Yeah, but the buildings are very similar in design, and there's two sets. So there's a breezeway that goes through both sets of buildings.
Okay. So they're very similar. So
it's easily confused, is what I'm saying, as far as locations, because the buildings look very similar.
okay. So you may have been easily confused, right?
I was confused, yes.
Okay. And Ms. Smith, during the earlier parts of her interview, she had only talked about one shooter, right?
I recall she said she saw someone with a long gun, and she heard shots. I don't recall if she indicated whether there's more than one shooter or not. I don't remember that. Should I refer
Okay.
to something?
So earlier on in the interview, or when in her interview, I think you talked about, she said some things which weren't consistent,
Yep.
and then you consoled her,
Yes.
and then she was more consistent after that, right?
Yes.
So when was it that she began telling you, back this up. At what point between those did she go from one shooter to two shooters?
I know when she described to me, she said she described the two guys that she was with, and she described each one of them having a different kind of weapon. I don't recall. I recall that, but I don't recall if she stated that she saw anybody shooting. She stated that she heard shots and ran.
Okay.
Saw both of them with guns, but I don't recall if she said she saw them shooting.
I guess my question was, when in her interview, before or after the consoling?
It was after the consoling.
Okay. Because before that, it was only one shooter, right?
I knew that story she was telling me was crap, so I really wasn't paying much attention to it.
Okay.
So I don't remember what she said.
And it was between what was the consoling? I'll go there.
What was what?
When you consoled her.
Mm-hmm.
What do you mean by that?
Well, I'm a husband and a father. I've got a daughter. I just spoke to her in a fatherly tone, assured her of her safety, and calmed her down and encouraged her to tell the truth.
Okay. But she didn't start doing that until after she was told to, I think, sing her ass off, right?
I don't recall if that was said or who said it.
You don't recall that?
I'm not saying it wasn't said. I just don't remember who said it. Yeah.
Okay. And there were discussions during that interview about whether she was implicating herself, right?
I don't recall.
Whether she could be going home or not?
I don't remember that.
She wasn't concerned with, or didn't seem as though she was concerned about getting in trouble?
She was concerned about getting in trouble, yeah.
Okay. And so I want to back it up. She came in, she's telling you a bunch of things, they're not adding up. You console her, and then she is telling you something consistent with the evidence, right?
Yes.
Okay. But that part didn't happen until you were the first one to bring up that someone had a rifle, right? As opposed to just a small gun, right?
I indicated that there were two types of shell casings, a rifle round and a small caliber.
Okay. Before that, she had not described two types of rounds, correct?
Like I said, I haven't seen that interview in quite a while. I do not recall.
Okay. You're the one who brought up a second person there to ambush, right?
I described two types of shell casings indicating that it was two shooters, yes. Implication there is two shooters.
Okay. So you made that implication, and then we had two shooters, right?
Yes.
Okay. What more did you do to confirm what she was telling you?
And what, do you have an example that you'd like me to answer? Because she told me a lot.
Right. She told you about different things that Mr. Mitchell did or Mr. Uten did, right?
Yes.
And those weren't consistent with what you learned from them, right?
Yeah, they were fairly consistent.
Okay. So when you spoke to Mr. Mitchell, that's when you learned about him putting a gun to her head?
Oh, yeah. She did say that about him, yeah.
Yeah.
Again, that's the story I didn't believe her, so I
Right.
forgot about it, yeah.
So it would make sense if she's telling you these stories that you would want to confirm them, right?
If it's the truth, yes.
Right. And she told you things about, well, let me ask you. You never went back to Mr. Uten or Mr. Mitchell and asked about whether everyone had been chatting together, like she told you, right?
Oh, no, they described in their interview that they had been texting with the girls.
Oh, I'm sorry. I meant that everyone, the defendants, everyone came out and was chatting together before this happened.
I don't think that came out with Mitchell and.
Okay.
Yes.
All right. So they didn't say it, she did, but you didn't go back and say, hey, this witness told me this. No?
No.
Okay. And you didn't go back and look at her Instagram records, right?
I don't think so, no.
So you couldn't confirm whether she said she'd been talking to the victim every day, right?
Bless you, the victim. No, I didn't.
Okay. You could have, though, right? Because you said you got a record, or you ordered them. Did a warrant for them?
Yes.
Okay. And she told you about a specific type of van that Mr. Ryan's mother drove, correct?
Yes.
You didn't go check and see if she actually had a van like that, did you?
Yes.
You did?
Yes.
And that's in your report?
I don't think so, but I did do it. I noticed it. Let me look see. It might be in the report. We went to go talk to his mother.
Mm-hmm. She was cooperative, right?
She was.
You didn't ask to search the van, did you?
No.
And that van would have been, based on what you were told, used basically as a getaway vehicle, right?
Yes.
So it could have a murder weapon in it, right?
Yes.
Could have gunshot residue all over the steering wheel, right?
No, unless it was shot from the car.
Okay. Those wouldn't transfer from someone's hands?
I don't know, maybe.
Maybe. But you didn't get a search warrant to check either of those things, did you?
No.
And within just a few hours, you had an address for Mr. Blaylock, correct?
I did.
And you didn't get a search warrant for that apartment either.
No.
So you made no effort to look for what would have been the alleged murder weapon, right?
That's correct.
Okay. That would have been useful, right? If you had that, that's great evidence.
I've worked 100 murders. I never got one.
Never.
Ms. Abbasi, let's pause for a minute and take our morning break. And if you do, you want him to look at whatever that
Sure.
portion was while we break? Okay. All right.
Sure. He's welcome to. And Officer, I'll hand you your other transcripts and you can look at whatever you need to.
And can I ask you to actually step outside if you don't mind?
Oh, sure.
Thanks. I've just got to deal with another matter. How about you start with whatever it is that you wanted him to actually, that you asked him on the stand about? Okay. I mean, you can give him all of them, but I'd like for him to start with the one that you specifically asked about.
They'll be here.
All right. Okay, so there's been some back and forth about the whole Mitchell, that's his last name, right, thing. And Ms. Abbasi, you said that you kind of gestured in a vague direction towards the holding cell door at the end of the day without mentioning anybody's name and asked who the witnesses would be tomorrow, which is now today. And the state's answer did not include either of those people. And then, of course, there was some point in time in which the state was maybe going to get Mr. Mitchell, and I don't know what they were going to do, put him on the stand, just, I don't know, as a concession to Ms. Abbasi, maybe? I don't know. Anyway, just FYI, Mr. Mitchell is here and available. I'm just letting y'all know that. And I kind of need to know before the lunch hour, or whenever this next, the witness that's on the stand right now is over with, if he's going to be called, let's go ahead and call him next so that he can be whatever's going to happen and then transported away back to where he has been staying before this time.
The issue raised on the defense is his messages would kind of affect what sort of road we went down with the defense. We've already gone down that road.
All right.
The mistrial has been denied. There's no further, I'm no longer insisting at this point he be called. Whatever damage has been done has been done. So working
All
with
right,
what we have.
just wanted to let y'all know. Okay, so then, does the state want to call him? If not, tell me now, and I'll have him shipped back.
No, I think this line of hearsay questions has cured any sort of issue as it relates to a mistrial and confronting Mr. Mitchell, since she's been able to do it without Mr. Mitchell even testifying.
All right. Thank you. Let's take our break.
The only person who ever gave you any indication that Mr. Ryan knew Mitchell, Mr. Uten, victim, anyone in the car, was Mariah. She's the only person who said they knew one another, right?
That you confused me a little bit. Say that again. Say it again.
The only person who said that Mr. Ryan knew Mr. Uten, the victim, Mr. Holmes, Mr. Mitchell, only person who said they knew each other was Mariah, correct?
I don't recall that.
Did you look at your interview?
Well, I'll be honest with you, I did, but I forgot what you asked me for to be looking for in there.
Okay.
Maybe it's a question. Ask me each person at a time. So, Mariah, you're saying Mariah said she knew Mitchell.
Mariah told you, was the only Mariah indicated, whether through this or something else, Mr. Ryan had some contact, knew the existence of Mr. Uten, Mr. Mitchell, Mr. Holmes, right? You never went to any of them and said, hey, do you know this guy?
No.
Okay. And they never, gave you any names saying, I think it was this person, or I have a problem with this, nothing.
They who?
Mr. Mitchell and Mr. Uten.
They said they did not know who shot at them.
Had no idea.
That's correct.
And didn't ask them if they, had any problems with Mr. Ryan or Mr. Blaylock, right?
Yeah, they said, they're correct, yeah.
Okay. And Mariah, she never told you anything about being locked in a basement, did she?
I don't recall that, no.
Okay. And she didn't tell you anything about Mr. Blaylock attacking her, did she?
Other than when Mr. Blaylock. Oh, no.
Okay.
No, not that I remember.
All right. And so based on the evidence you had, the person who fired the 7.62 was tall, right?
I was described, he was described as being tall, I believe. Just
All right.
a second, let me double check it. As they said.
And I can get you a transcript of your interview with Mr. Uten if that further helps too.
I bet you can. Let's see. Yes.
Okay. So Mr. 7.62 is tall, and based on all of that evidence, was your conclusion that Mr. Blaylock was the one with the 7.62, right? Page 18?
Page 18. Of what? Which one am I looking at?
Your report.
Well, if you got a page 18, you're doing better than me. I got 17 pages.
Oh.
Okay, I see what you're referring to, yes.
Yep. So final conclusion you came to based on everything you reviewed was that Mr. Blaylock had the rifle.
That's what I wrote, yes.
Gotcha. All right, so we have rifle rounds, and then we have all these other casings from a smaller gun, from a 9mm, correct?
Yes.
All right. And those casings were found very, very close to the vehicle where the victim was, correct?
There were casings on top of the car, yes.
Okay. And casings on top of the car, you don't know how they got there, did you? Or do you?
I didn't see them be placed there or fall there, no.
Okay. Did you speak to the EMS, the emergency services people who would have been there responding?
They were gone when I got there.
Okay. So you're not sure whether they had to move anything to get to Mr. Holmes?
It was obvious that the hat we found on top of the car was placed there by someone.
Right.
I don't know who. But I guess it's plausible that somebody would say, hey, there's a shell casing, let's put it on top of the car.
Yeah. So they wouldn't want to lose it.
Don't know why they do that, but yeah.
Okay. So you discussed with Mr. Mitchell and Mr. Uten whether they had guns, correct?
Yes.
They both had guns, right?
Yes.
And you never asked them if they shot, did you?
Mitchell said his gun was empty.
Okay.
Uten, I don't recall ever asking that specific question.
Right. You didn't ask him what kind of a gun he had, right?
I don't recall asking him.
You asked him what happened to it, though, later, right?
Yes.
And he indicated to you that you should...
All of this is hearsay. What Mr. Whoever indicated to whoever.
Sustained.
Okay. Did you have an occasion to either you yourself or have somebody go looking in the woods for a firearm?
Wasn't me, but yes.
Okay. And beyond that, you did not have any follow-up to tracking down those guns, right?
That's correct.
All right. And your reason for that, you previously testified, was you had no reason to, right?
I had no further leads. Once we tried to find them and couldn't, based on where they said they put them,
Okay.
there was nowhere else to go.
So you had no reason to try and find out whether Mr. Uten was the one who fired all those 9mm.
Say that again?
So you had no reason to try and figure out if Mr. Uten is the person who fired all those 9mm.
Right, I didn't try.
Because if he did, that would be your second shooter, right?
Your Honor, objection calls for speculation.
Sustained.
You, at some point, had an occasion to review Mr. Mitchell's Instagram records, correct?
Again, I'm not a computer guy.
Far later.
I allow other people on the team examine those. I trust them in what they can do because a teenager is better than me on that stuff.
Yep.
So I looked at the report or what was given to me. Did not do a deep dive, no ma'am.
No. No deep dive. You didn't look at them.
Say it again?
No deep dive. I mean, you did not look at them, right?
I don't recall if I did, yeah.
Okay. So you never did any follow-up with Mr. Mitchell about him shooting back, did you?
No.
But you learned that at some point he said he did, right? Or they did.
Yes, I did hear that, yes.
Thank you, Detective.
Oh, you're welcome. You need to give this stuff back?
Are there
That's all yours. You're welcome.
other defense counsel with questions for this witness?
Good morning, Detective Hogan.
Take the time. Good morning. Good morning.
We've met before, but my name's Max Shard. I represent Shannon Stillwell, okay?
Okay.
All right, and the case that we're talking today does not involve Shannon Stillwell at all, does it?
Not that I know of, no.
Okay. I just wanted to ask you one question on cross. you were asked about testing a car, the inside of a car for gunshot residue.
Right, yeah.
And you responded that it would not make any sense to do so unless a gun was shot from that car, correct?
That would be the most obvious reason to do so, yes.
Okay,
To test
so
for that.
if a gun is shot from inside a car, if your investigation leads you to believe that a gun was shot from inside a car, you certainly would test for gunshot residue, correct?
If there was any question that a gun was used inside the car, so if there was an allegation that it was, and
Yep.
there was reason to believe that it wasn't, we needed to prove that a gun was used in the car, then certainly we should process the inside of the car for gunshot residue.
Okay, when you say process inside the car for gunshot residue, what does that mean?
Well, we asked the ID unit. I've watched them do it several times. They have a Q-tip, and they swab areas, and they preserve that Q-tip, which gets sent to the GBI crime lab. And then they do their analysis, their whiz bank stuff over there to say if there's any presence of gunpowder, I guess is what it is.
And we're talking about microscopic particles,
Yeah,
right?
if you shoot a weapon anywhere, if somebody shot in here, the residue would be however tiny, microscopic, but it would be here on everybody, everywhere. Yeah,
It would go all over.
yeah, it goes everywhere.
Okay, and you would ask the collection team, we'll say, to the crime scene technicians, I guess is the formal term, correct?
Yes.
You would ask them to collect from the different areas within the car.
That's correct.
Are there any specific areas that you would have them focus on?
I generally let them do their job. They know more about that stuff than me. I ask them to process it, and I allow them to do it.
Okay.
So wherever areas they are. Another's, the GBI has been a little more stringent on their testing of that. They're getting away from gunshot residue because of the fact it goes everywhere. It doesn't really prove anything.
Okay, so the concern when they're going away from it is not that it gives false negatives, but it gives false positives.
Right. So, for example, if you're a gunshot victim, and you're obviously a gunshot victim, guys that in the past I know have tried to test them for gunshot residue. Well, that's kind of silly because they are a gunshot victim. They're going to have gunshot residue on them. Also, the fact that if they're in a room such as this or other people, and somebody shoots, and then that person gets away, but somebody else is alleged to be the shooter. Well, if he was in the same room, he's going to have gunshot residue on him as well because it goes everywhere.
So it sounds like what you're saying, if you get a positive result from gunshot residue, it may be unreliable for proving what you're intending it to prove.
You don't necessarily have to be the shooter if you were in the room when the shot went off.
But if you get it, but from what I'm understanding, if you get a negative, that's still a reliable result. It's just the positives can mean different things.
Yes.
All right. Great. And in your experience at times, you said you defer to the experts on the collection method. Have you known them to remove different parts of a car for further testing for gunshot residue?
Yes. Oh.
It's changed.
I can approach it. It is going to be relevant.
All right, I'll give you.
And I'm just going to ask one more question. Is one of those parts that the experts remove at times the headliner of the car?
Yes.
Okay. Thank you. No further questions.
You're welcome.
Any other defense? Go ahead.
Good morning.
Good morning, Mr. Steele.
How are you?
I'm great. Thank you.
I'd like to ask you, in your work, have you ever had the need or the opportunity to ask for and secure surveillance cameras from businesses?
Several occasions, yes.
Okay. Can you tell the ladies and gentlemen jury, in your experience, have you ever had a surveillance camera operation where it would be a specific period of time that was captured. The images were captured by the surveillance camera.
Sure. Every system's different. There are some, from my experience, some common denominators. Most surveillance systems capture a certain period of time that's generally around 2 weeks. And after those 2 weeks time period, it stops. You can kind of imagine that you're shoving the video into a tube, and as it comes out, there's just so much space to capture and to maintain. So as you capture more video, it starts falling off the backside after 2 weeks. So for example, if 3 weeks ago there was a crime that we became aware of and we needed to try to get the video, we call if it's past that 2 week time period, the video is no longer accessible. It's been deleted. It's been overwritten and it's gone.
So in your example about the 3 weeks, so a video can hold up to 2 weeks of information is what you're telling the jurors in our example.
It's kind of a general rule, Brian. But there are systems that capture and they keep them for longer periods of time, but those are expensive to maintain, and that's pretty rare that we have, but they're out there.
So if, just hypothetically, if we start on day 1 and the surveillance equipment can hold 2 weeks, so on day 14, from day 1 to day 14, it's all there if it's all working correctly. That's what I hear you say.
Yes.
I'm going to object to relevance.
It goes back.
Overruled.
Now, on day 15, so day 14 ends, now it's day 15. Are you telling the jury that in your experience, day 1 is now gone, so now we'd have from day 2 to day 15?
That's my experience, yes.
Okay. Have you ever, tell the ladies and gentlemen jury, on day 15, so day 15 starts, all day 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 are gone?
Without a catastrophic failure of the system, I have never heard of that. No.
Thank you. Thank you, Your Honor.